All right. So good morning, everyone. Before we get to the substance of today's meeting, I just want to, first of all, welcome you to our new offices at 100 Church Street. And as you all know, as we talked about before, pursuant to the new open meeting laws, this meeting is going to be recorded. And we also have to create a transcript that will accompany the video recording and the audio. And so what I'm going to ask is, as we proceed in this new way, if you wait to be recognized before speaking, so you raise your hand if you have a question or comment, so that you can be recognized, so you end up having a clean record. That'd be tremendously helpful. Each speaker who is presenting, I'll ask them to go to the podium, and then of course any presentation will be projected behind me. So let us begin with today's Environmental Control Board meeting, March 27th, 2014. First order of business, is there a motion to adopt the minutes from our last meeting, February 27th? All in favor? Anyone against? Any abstentions? Okay, thank you.
Can you just make a little loud?
Sure. Can you hear me now?
Let me just come a little bit closer.
How's that?
Good.
Okay, I'll try to speak up as well.
Thank you.
Dan, can you hear me back there?
I can.
Yeah? Okay, fair enough. Okay, the first item on our agenda, I believe that Madeline McCoy is going to present from the Department of Sanitation regarding penalty schedules.
Thank you, Sue. Sanitation has a very minor change to its penalty schedule. Local Law 77 of 2013 changed Section 16306 by establishing a pilot program for our organics program. In doing so, it renumbered several sections that we currently enforce for generators of yard waste, both residential and landscapers. So this change just changes the provisions of those codes from 16308E to 16308F, and from 16308F to G, and from F to G. Very minor change. All penalty amendments remain exactly the same.
Okay. Any questions for Madeline on that? No substantive changes?
No
beyond
substantive.
the ministerial changes. Okay. Is there a motion to approve? Anyone against? Abstentions? Okay, thank you. And Emily Lally is just joining us now.
Okay.
Emily, as I was just telling everyone, since this is our first time being recorded, before you speak, ask questions, comment, I just ask everyone to raise their hands so we can acknowledge you. Okay, so we have a clean record and a clean transcript. Thank you so much. The next item up on our agenda, Teo, person?
Actually, Joseph Gregory is here to present.
Oh, that's right. Mr. Gregory from the Fire Department is going to be presenting on changes to the notice of violation form. And we've all been provided a copy of it.
So just to clarify, this is an additional copy because there was some typographical error on the proof on page 9. Can you just, I'm sorry, could you, sorry, there was a typographical error on page 9 on the proof. So the new one corrects that.
Good morning. The New York City Fire Department is requesting the Environmental Control Board's approval of its notice of violation form. Changes or amendments to the NOV form reflect amendments to Section 109-02 of Title III of the Rules of the City of New York. That section establishes the various violation categories or VCs for the purpose of enforcing provisions of the New York City Fire Code and other laws and rules and regulations that the Fire Department is authorized to enforce. Pursuant to a statement of substantial need for early implementation, the changes to Section 109-02 will take effect on March 30th, 2014. This is the same day as the 2013 amendments to the Fire Code also slated to take effect. On the NOV itself, The violation categories that the fire department is proposing to amend are the VC5, VC8, VC9, VC24, and VC30. As members of the board have already received correspondence which sets forth the exact language, I will only highlight the notable differences in the violation categories. On the NOV for violation category 5, the proposed heading will remove the reference to the posting of permits. The heading will bear the caption record keeping. The violation category amendment follows the amended section of the rule by deleting any reference to the posting of permits. Essentially, violation category 5 has been made more specific. Infractions that involve the posting of the permits will be charged under VC6, which remains unchanged and bears the heading signs, postings, notices, and instructions. On the NOV with respect to violation category 8, the proposed heading will read storage, accumulation, and removal of combustible material and waste. The fire department removed the word timely within the charging language and added the word storage and material. The violation category 8 amendment to the NOV follows the amended section of the rule by expanding the list of infractions to include the storage of combustible substances other than just waste material. On the NOV with respect to violation category 9, the caption currently reads means of egress. The proposed heading on the NOV will add the phrase rooftop access. Within the charging language on the NOV, we're adding the word access. Violation category 9 amendment to the NOV is consistent with the amended section of the rule which specifically was clarified to include rooftop access. With the proliferation of cell phone towers and the expanded use of green technologies such as solar panels, it has become increasingly important to ensure that firefighters have unimpeded access to the roof in the event of a fire or other emergency. With respect to violation category 24, the proposed heading showed read storage of hazardous materials, commodities. There will not be any change in the charging language of the NOV. Prior to the amendment, violation category 24 addressed hazardous and combustible materials. However, as combustible materials are charged under VC8, the fire department will no longer enforce under violation category 24. The fire department added the term commodities to the violation category 24 as certain commodities trigger certain storage requirements. On the NOV with respect to violation category 30, the heading currently reads fire safety in office buildings, hotels, and motels. The proposed heading on the NOV will read emergency planning and preparedness. The charging language cites as a violation the failure to comply with specific emergency planning and preparedness requirements. The proposed changes are consistent with the amended section of the rule. The amendment takes into consideration the inclusion of both fire and non-fire emergencies. It also was amended to include all buildings and occupancies subject to emergency preparedness requirements, not just office buildings, hotels, and motels. Finally, in addition to some minor ministerial changes, we are proposing to change the skin color descriptions to the complexion types on affidavits and certificates of service in the section that's provided to describe a person served with the NOV. And that concludes the notable differences with respect to the violation.
Okay, let's take any questions or comments for Mr. Gregory. Dan Albano?
The changes that, specifically that change to the affidavit of service about skin color, is this, are we waiting till the existing stock of NOVs peters out, or are we going to use these right away?
Well, my understanding is that we're going to continue to use the NOVs that we have in stock, and we're going to use the new ones as they come into place.
Our stock is very low right now. We would have been ordering them, the new NOVs, probably 3 weeks ago, had we not had these changes to the rule. So these will come out very quickly, but the stock that's already been distributed will continue to be distributed.
We have the same problem, with the affidavit of service and some other issues on the NOV, but I don't know, I think our stock is pretty extensive.
Okay. Mr. Mr. Martinez just joined us, he wasn't with us when we first started the meeting. Your comments?
Yes, regarding violation code 5, I noticed in the NOV you indicate fail to maintain/produce, but on the description of the NOV you indicate failure to maintain and/or produce. I know some of the other charges include the and/or clause. I'm wondering what that was taken out.
So you repeat the question, Linda?
Yes, on the NOV, if you look at violation code 5 record keeping, this indicates
I'm sorry, can you
fail.
repeat that?
On the NOV, if you look at violation code 5, record keeping indicates fail to maintain/produce records. But on the description of the violation code 5 record keeping indicates failure to maintain and/or produce required record keeping. I'm concerned about the clause and/or. I'm wondering why it was left out. Because I know some of the other charges, you do include the and/or clause.
Sure.
This is just a spacing issue for the formatting and how they formatted it. When there's a selection, if you notice in most of the violation categories, when there's a selection between different things, such as on VC1, portable fire extinguishers, hoses/other, on VC4, manufacturer, store, handle, use, VC17, which is on the top of the next column, certificate of fitness, qualification, they just use a slash most of the time. Sometimes they'll use an and or an or if they're, I guess, exclusive, but that's just how it's been, and I think it's just a formatting issue when it was.
How do you think that would impact the respondent receiving this?
How do I think?
Well, Mr. Martinez asked the question.
Yeah,
so
that was what I wanted
What's your
to know.
concern? What's your concern?
I'm concerned how that would be read. I mean, I think there's a difference between and, maintain, I read it as maintain or rather than, maintain and or. I think there's a slight difference. And I don't know whether that would impact on the respondent or not, but some of the other violations do include that. So, it just stood out.
Our position would be that it would not impact. If it's only one, they circle the one that it is. If it's either, it could be either. They either circle both or just don't circle either.
Okay, any other questions? Elizabeth?
I have a question, it's actually not on one of the changes, but it's in the language about the certificate of correction. In the second paragraph, under notice of violation and order to correct and certify correction at the top, it says the certificate of correction must be received by the Bureau of Legal Affairs by whatever date is put there.
Mhm.
And then the next sentence says, first offenders whose proof of correction is accepted by the fire department by such date will avoid a hearing. And there seems to be a difference there about, if I thought I just needed to submit my proof of correction by a certain date, but and we've seen it in some cases, that might not mean that it's accepted on that date, and I might not avoid a hearing. So I find the language could be possibly confusing to somebody who receives it.
The language is that way on purpose. There is a requirement that it be received by a particular day. If we don't have an opportunity to review it on that day, and we need to review it after that day, we are still able to submit the correction, and they would still avoid the hearing. However, just because it's received doesn't mean that it will be accepted. So if we receive it on the first, let's say they have until the 15th of the month to receive it. If we get it by the 15th and we don't, let's say that's a Friday, we review it on Monday the 18th and we accept it, that would be fine. But if we receive it on the 15th and it's not acceptable, then we'll still let them know that it's not acceptable and they have to go to the hearing.
I see, so it's essentially, even if it's not accepted by that date because of just administrative timing, it would be considered accepted as of that date?
Correct,
Okay.
as long as it's received on that date.
Okay.
Okay. Any other questions, comments for the fire department? I have one sort of global comment about the notice of violation. And it's a sort of an ongoing concern in terms of the Environmental Control Board's relationship to respondents and to the city agencies, is that we stand as a neutral body to have fair hearings, right? So we are in a position of neutral arbiter of facts and we render decisions. Now, when someone receives this kind of notice of violation, the first thing they see up here is Environmental Control Board. It creates the impression for those who don't know that somehow the Environmental Control Board is issuing the violation. And we see that again and again. There's nothing on here visually except for a small seal that I can barely read that identifies this as issuing from the fire department. And so my global concern is that we have something more prominent, because the only prominent sort of logo on there or title on there is from the Environmental Control Board. So I wonder if that's something that globally we can address. If you want to take it under advisement and come back to that, but that's an ongoing concern and something that now that the fire department is going to be issuing these notices of violation, I wish could be addressed up front, because it creates a public perception that somehow the court is also the issuing agency, and that's just not correct. Elizabeth?
Well, I'm just kind of following from your comment. I'm wondering if the please take notice language could or should be amended. Instead of saying the premises cited above is in violation, should it be amended to say that the fire department or the petitioner has found the premises cited above in violation?
Well, this is the thing. This is not ours, so we're not saying, you know, we think there may be violation. This is the fire department's finding or a statement of allegation, right? So I leave that to you, but that's my global concern. Yeah, Tom Schwetner?
Thank you. It does note the petitioner New York City Fire Department versus respondent, and it does further in the part that was cited earlier, is further ordered by the fire commissioner. Your point is well taken, of course, but there are some places in here where it does mention that it is the fire department issuing the NOV.
Yeah, I think these kinds of things would not mistake people who read the fine print, like you and I, lawyers. But I think the general public, when you get something like that, the first thing you see is Environmental Control Board, and you think, what do they have to do with it? Ernie, did you have a comment? I saw you gesture, and I just
No, I
wanted to-
think not.
Okay.
I'm gonna-
Any other comments or questions?
Thank you.
So just to let you know, I mean, we are kind of running low on the NOV stock that we have, and so we would like to get these out, but this is definitely something that we can look into on how to fix better for the next time, if that would be acceptable.
Well, my understanding is that you produce these that will last for,
By the year,
yeah, so,
maybe, depending on how, although issuance has been going up, so we've been
Yeah.
ordering them much more frequently
Yeah.
lately.
you know, my preference would be in that bucket up top to say fire department.
I'm just concerned that that would take a number of additional approvals at this point, and we're already going to run out of notice violations before this.
Well, I mean, I think that's an operational
Yeah,
issue, you can
I'm
just
just-
run up the chain.
I'm just wondering if that's, something that would
It's,
hold this
I think
up,
it's
or if
important to
it's,
this organization.
Mhm.
I would like to see that addressed, but I leave that to the board.
Okay.
So with that, maybe we could also approve it subject to that change. But is there any other comments or questions up to now? Anything else for Mr. Gregory?
No.
No? Okay. So let's put this to a vote. Is there a motion to approve the form? Anyone against? Any abstentions?
We're approving the form subject
Well-
to some of the concerns that Mr. Martinez raised, that you raised, and we're approving the form as it is.
Well, the question would be, would you approve the form as it stands? That's the first question. Okay? So is there a motion to approve the form as it stands without any changes? Okay. Is there a motion to, anybody else who would approve subject to the changes? 2. Any abstentions? Okay. All right, thank you, everyone.
Could I just ask a question on
Yes,
that?
sir.
Can I
So,
take your name? I'm sorry.
excuse me?
Your name, please?
Russell Buchanan.
Thank you.
For future revisions of NLV forms, because I know our air, noise, and asbestos forms are formatted similarly. They say ECB, City of New York on the top. Is that something that you want agencies to change as they are redoing?
It's something
their
that I'd like
forms?
agencies to explore, whether, because I think that for your sake and for our sake, it doesn't help to have the public confused about who the issuing person or group is. And so very often when these things come to us, they'll say, why did you give us this ticket? And we, have to send them back to the issuing agency. They're very confused about who they're getting the ticket from. And the fact that then, well, are you giving me the ticket and then are you hearing the same ticket? So that's where the confusion comes in. So that's a long-winded way of saying, yes, I would like agencies to really reconsider revising their NOVs as they come up to more prominently feature the issuing agency itself as the issuer.
Because I know ours
And-
don't have a logo on it.
Yeah, some identifier. Yes, Madeline?
See, what about the paper tickets that we receive from ECB? They prominently say environmental control board on them.
What? Not anymore.
They don't anymore?
No, they removed it.
So does that mean also we should be revising our handhelds, which we just ordered stock a couple months ago on?
Well, when it comes out for the next cycle, it's just something I'd like you to consider because I think it's more helpful. Okay. Tom?
This is maybe a silly observation, but when I saw this initially and I saw Vanguard Direct, I conflated it with a mutual fund company. And I don't know what Vanguard is, but maybe that's the spot where you put fire department.
This is just a tab,
Yes.
and then they're tear-off sheets.
I see.
So nobody
Oh.
actually sees that, but that is the vendor who produces these.
I immediately thought it was a mutual fund company, and I thought I received the wrong
Yeah, but-
information from
I-
Francis, so, okay.
I understand that,
All
but
right.
that company is the company
I
that
see.
does the
Okay.
NOVs. So when somebody gets this, as you see, there's a number of pages, so it's a
Certainly.
5-part form, and they're perforated right at that line, that dotted line under the Vanguard Direct
And
logo.
so the respondent
So
would never see it?
The respondent does not see that.
Got it.
I don't even know if it prints on there. I'm not sure, but it is on this form.
Okay. Any other questions, comments before we move on? Okay, thank you. So the next item up on the agenda is a presentation by Russ McKinnis for the Department of Environmental Protection's request for cease and desist orders. Russ?
Okay, so this month, we have the usual 28 requests for cease and desist orders pertaining to failure to install backflow prevention devices. So I guess if there are any questions on any of those. Take those first.
And do you want to do them all together, Russ? or-
We'll do the 28 backflow ones first, and then there are 2 of them.
Okay. So, as you know, we've all received the packet with the 28 black flow details. Any questions for us on those? Okay, is there a motion to approve? We're going to do this collectively. Is there a motion to approve all 28? Thank you very much. And you're abstaining?
Yes.
On that vote?
Yes,
Okay.
absolutely.
Um,
And then we have 2 requests for cease and desist orders under the air code. These are the same as the 6 that were made at the last board meeting. These are for locations where the respondent has been cited for failing to renew the certificate of operation for a boiler that is using number 6 fuel oil. They have been adjudicated in violation, It has been over 30 days since they were adjudicated in violation, and the certificate has not been renewed, based on which the department is requesting in each of these cases for 2200 Grand Avenue and 2198 Kruger Avenue, both in the Bronx, that the board issue an order to cease and desist.
Any questions for Ross on either of those two requests? Emily?
I just wanted to ask, are either of them residential buildings? And then, is this still going to go through a process where they come in for their pre-sealing hearing? This is not-
The cease and desist hearing will be for the purpose of them coming into compliance with the requirement to renew the certificate of operation. Since they are no longer able to renew a certificate of operation to use number 6 oil, they will essentially be forced to convert to 4 or 2 or natural gas in order to comply with the order.
So I'm just wondering what happens to if there are residential tenants in that time frame. If they say they're forced to convert, so you can shut their own boiler, but they don't get a new boiler.
The question is, could you-
Well, if it's a residential, I'm just
Are there-
concerned if it's residential.
It is
Or are there
residential.
those signs residential?
I suspect that almost all of these will be apartment buildings. So if the equipment has to be sealed, they'll have to get a temporary boiler. I mean, I believe that last summer, when we brought this concept to the board to do these cease and desists, that question was asked. And we did make inquiries, and buildings get temporary boilers all the time because the boiler breaks or whatever. And if we did have to seal one of these, that's what they would have to do.
Elizabeth?
I've been hearing reports on the news about the public housing buildings and the Rockaways that have temporary boilers, and that they're costing $1 million per month.
Well, that may be, you see, yeah, okay. Is there?
So I just wanted to raise that. When we first were presented with this, that information, I don't think I have heard that. It seems like it's not just a simple matter.
Well, I can inform the board maybe as to what the average cost of a temporary boiler would be next month. I don't know why the Housing Authority is paying $1 million a month for a boiler, but they don't cost $1 million a month.
And I don't know if it's impacted obviously by the size of the boiler you need and how many units are issued.
And they would only be sealed again if they either disregarded the cease and desist hearing or refused to comply. But by next summer, everybody will have to be off number 6 oil. So,
You may have addressed
Excuse
this.
me. I just want to recognize you before speaking, okay? So Ms. Martinez.
You may have addressed this when you brought this proposal before us the first time, but how long does it take to convert from number 6 to the proper number of oil?
the conversion process from 6 to 4 is very easy and not that expensive. Some buildings may want to convert to natural gas, and so we may get some people who get these cease and desist orders who will come in and they will say, we don't want to convert to 4 right away. Con Ed is going to bring us natural gas in 3 months, and we want to wait for natural gas. We want everybody to convert to natural gas who says they want to convert to natural gas. So in those circumstances, we will agree to appropriate adjournments of the cease and desist hearing to allow them to convert to natural gas if that's what they want to do.
Any other questions for Mr. Hughes on this issue? Okay, well, let's go ahead with the vote. So we're going to vote on this collectively, okay, on both of these requests. Is there a motion to approve? Anyone against? Okay, abstentions?
Abstention. And just for an informational note on one of the 6 that was approved last month, because of my misreading of the inspector's handwriting on the ticket, the request was put in for 301 West 72nd Street. In fact, the ticket was issued for 305 West 72nd Street, and when I pointed this out to ECD staff, they said that I should just mention that to the board this month, and the cease and desist order will be revised so that it goes to the right address.
Thank you for that.
Thank you.
Okay. Next, we have pre-sealing reports. Kelly Corso from the Environmental Control Board is going to be presenting on those for us.
Good morning. We have 21 pre-sealing reports for today's board, all of which were issued after live hearings. 20 of the pre-sealing reports pertain to failure to install backflow device violations. All 20 reports recommend that there be no sealing or other action given in respondent's compliance. The remaining pre-sealing report pertains to C&D Order 2013/C for a violation of the air code. And I'll discuss this one in a little bit more detail. In this case, a predicate violation was issued in January 2011 to Oz Realty LLC for failure to obtain a valid operating certificate for boiler equipment at a multiple dwelling located at 1920 Osborne Place in the Bronx. A default judgment and order was issued for the predicate violation in February 2011, imposing a penalty and ordering compliance with the air code. An inspection of the equipment in July of 2013 showed that the respondent continued to operate the boiler in violation of the air code, and subsequently a C&D order was approved by the board in July of 2013. The pre-sealing hearing was held on March 11, 2014, following 8 adjournments. At the hearing, the respondent's representative provided proof of a valid operating certificate from DEP that brings the equipment into compliance with the air code. Based on the evidence of compliance, ALJ Court has recommended that the sealing be stayed pending reinspection and further reinspection by DEP of the boiler equipment unit confirming no air code violation.
That's it? Okay. Any questions for Kelly on that? I just wanted to mention, since I always like to keep you informed of what's going on in ECB, since you are have a vested interest in all of that. Kelly Corso used to be the managing attorney for the special motion part, reviewing all of the cases that fell into default and people make motions to reopen. She's since moved on to being the assistant director for adjudications, overseeing a few of our offices, and was recently promoted to assistant commissioner. So I just wanted to let you know that. And she's, I think a lot of the agencies have contact with her. She does a great job for us, and we're very, very proud of her advancement. So thank you, Kelly. Thank you. Okay. So with that, is there? I'm sorry. Did we take a vote on it? I was so busy congratulating you. Sorry about that. Is there a motion to approve? Anyone against? Abstentions? Okay. So now we are at the point where we have to go into executive session to discuss litigation and appeals. Is there a motion to go into executive session? Okay. Anyone who isn't a member of OECD will have to excuse us for the time being.
No, it's 1 in the morning.
Okay, we are back in. We're back in public session. If everyone can settle down so that we have a clean transcript. We're waiting for the court reporter to return.
I think you're gonna. I think you'll win this one once the vote is switched.
I thought we voted already.
No, that was straw poll.
Oh, she's out in the waiting room.
She made it misunderstood.
No.
Shouldn't the ladies know?
debate.
Who took her out? Did you take her out?
She probably waited for so long because I need to go to the bathroom. She's like, all right, I'll just go. And then this is she left.
It's out in the hallway making noise. Playing the radio.
About 54 decibels.
And that's not all that loud. 54 decibels is very loud.
Is that right? I have no idea.
Right? Pretty loud?
Okay.
It's an exponential, it's logarithmic, right?
All right, everyone, we are
Is this on?
being
Yes,
recorded.
everything's
And our court reporter is back with us. We are again in public session, and we have heard extensive back and forth on the matter of New York City versus Pylon Bar and Restaurant Corporation Appeal Number 1301. And now we're going to take a vote. We have a number of different options, and so I ask you to raise your hand when you agree with the option that we are articulating. The first option is to sustain the violation, and that is to reverse the ALJ's finding, sustain the violation on the grounds that the decibel level exceeded the legal level. So the first option is to sustain the violation, which would essentially reverse the ALJ's finding on the grounds that the decibel level exceeded the legal level. The agreement between the parties was ambiguous and should not have been reasonably relied upon and could not be then used as a defense in this case. So that's option one. So those of you who would vote for option one to sustain the violation, please raise your hand. And we have 4. The second option is to dismiss the violation and to sustain the ALJ's finding. So essentially, we would be saying that the parties reached an agreement and that the respondent reasonably relied on that agreement. However, we would add a caveat that the board finds that the agreement resulted in a noise level that did exceed the legal level and was ineffective in maintaining that legal requirement, and so the agreement cannot be relied upon going forward. That is option number 2. Those of you in favor of that option, may I see a show of hands, please? Okay. Option number 3 would find the respondent in violation. It would reverse the ALJ's finding, and it would find that the respondent did violate, that there was a violation, but that the fine is mitigated to the minimum of $2,000, and that the bar can no longer, the respondent, bar, Pylon Bar, can no longer rely on the agreement, and it must come into compliance with the legal noise level of 42 decibels. So those of you who would vote for option 3, and I see a show of hands, please. Okay. And abstentions? Thank you. All right. So I think we have our outcome. So the other bit of business is that there was 2 appeals panels from March 6th and March 20th. And I'll ask if we could vote on those collectively. Anyone affirming those decisions? Anyone against? Any abstentions? Okay. So I think that concludes our new business. Tom, is that all we have for appeals?
There is, but I'd like to say on the record that our turnaround time this month was the lowest it's been for this 110 appeals, just over 77 days.
Fantastic.
Excellent.
Thank you for that. All right, well, with that, thank you for your time, your effort. I know this was quite a debate, but thank you so much for your service. I'm always glad when you have this kind of likeness to educate the results in the record. And this meeting is adjourned. Everyone, motion to adjourn? Thank you.
Procedure.
understand,